an introduction, and I want to turn the program over to the reason that you're all here, to hear from Brendon Woods. So I am Karen Wong, for those of you who don't know me. I am the Executive Director of the David J. Epstein Program in Public Interest Law and Policy here at the Law School. And I want to welcome you to our Spring 2022 Margaret Levy Public Interest Fellow Lecture, which is on, as you can see, the topic of Black Lives Matter on juries. Before we begin, I do want to acknowledge our presence today on the traditional, ancestral, and unceded territory of the Tongva people and their role as the traditional land caretakers of Tawanggar, which includes the Los Angeles Basin, which includes, of course, the UCLA Law Campus. So today is our first in-person big speaker event in more than 2 years, and I am really delighted that we are returning to semi-normalcy with the Levy Fellows Lecture and with this particular talk. So I want to thank, first of all, our UCLA Law alumni, Margaret Levy, whose generosity has allowed UCLA Law and the Epstein Program to invite leading public interest advocates to spend time speaking to students like you and providing mentoring, as well as their kind of wisdom and guidance and experience on various public interest issues. So it's with great excitement that I now introduce our Spring 2022 Levy Fellow, who is Brendon Woods, who is the public defender of Alameda County. For those that don't know, that is up in Northern California, the Bay Area, the home of Oakland and other cities, but most notably Oakland. So from a young age, Mr. Woods had formative experiences with law enforcement that led him towards a career in public defense, and he has devoted now more than 20 years to criminal defense litigation and representation. I find it particularly inspirational that Mr. Woods started right out of law school as a post-bar law clerk at the Alameda County Public Defender, and then in 2012 he became the Alameda County Chief Public Defender. So he has spent his career in this office and now is leading, which I think is amazing. And he's the first Black Chief PD in that county's history. As the Alameda County Public Defender, Mr. Woods is committed to providing holistic representation to his clients and was an early leader in addressing issues like the intersection of immigration and criminal law. He's also advocated for important criminal legal system policy changes that affect his clients, such as cash bail and fines and fee reform. He feels fortunate to fight for those battling systems of oppression and strives to reshape the discourse and nature of public defense and criminal justice as a whole. And I really like that he has both been on the ground in individual public defense, but is also seeking systemic change, which I know many of you interested in public defense struggle with the individualized nature of cases versus the larger problems with the system. So this will be particularly great to have him here for a few days to share his perspective with us. So we're really thrilled to host Brendon Woods as our Spring 2022 Levy Fellow. He's going to speak for about 40 minutes or so over this next hour and hopes to save some time at the end for questions. And so save your questions for the end. And with that, please join me in welcoming Brendon Woods.
So good afternoon. Thank you for the introduction. And thank you, UCLA, for having me as your Margaret Levy Public Interest Fellow. So I'm very excited to be here. And maybe some of you don't know that I actually did go to school here for a short period of time. I took the LSAT right down the street here, so that's some ties to LA. So the title of my talk here today is Black Lives Matter on Juries. So to be clear, they don't just matter on juries, right? Right? Black Lives Matter in healthcare, they matter in housing, they matter in employment, in policing, in voting, they matter in every single sector of society. But I do not think there's been a true appreciation of how much they matter on juries. And to that end, there has not been a true appreciation of the historical, deliberate, intentional, and relentless efforts to keep people of color, to keep Black people from juries. So that's why I'm here. That's why I'm very excited to talk to you today. As you've heard, I've spent my whole entire life, my legal life, at the Alameda County Public Defender's Office. That's where I started, that's where I've been, that's where I'm going to end up. But you're going to have to roll me out of here. I love this job. So much time fighting to get people out of cages. And I can tell you more about why I do this work. I think it's time for that on Wednesday. How's that for advertising, huh? But hopefully today, when we're done, you will see the real importance of this topic. People of color, especially black people, have made up the majority of people that are policed, prosecuted, and caged by this criminal legal system. And at the same time, the system, as it is built and constructed, is meant to keep us in a certain place where we have the least voice. Where the system that prosecutes us the most, we're kept from it and removed intentionally. Removed from being decision makers in the process. And so we have to look at why that is. And it's a vicious cycle. It's a very vicious cycle because prosecutors who are prosecuting cases know that juries won't challenge their cases if they know they can get convictions easier. That drives up the punishment. That drives up the charges. It drives up the incarceration rate. So what we want, what we need, what we should strive for are diverse juries with people of color who are going to hold the prosecutors to their burden of proof. Who are going to make them prove the case. And studies have shown time and time again that exist when our juries are the worst. So, as you've heard, I've been doing this work for quite some time, for quite a long time. I wasn't always the boss. There was a tasteful time when I had real cases, when I was trying cases. And one of the most horrible feelings, one of the worst feelings you have as a lawyer, is sitting there trying a case with a young black client who trusts you, who doesn't trust you with their case, literally trusting you with their life, their family's life. And you were trying that case, and the jury comes in, and there's not a single black person that will be sitting in the judgment of your client. That happens all the time. And that is a horrific feeling. It is terrifying. It's terrifying for you as a lawyer, and it's more terrifying for the client you're representing. Because they will see no one that is familiar to them. And they look at you, and they think, God, what is this? Not the system was supposed to provide me with an impartial jury, right? That's what we're supposed to be striving for. That's what we in America is touted as the hallmark of our system. That's what sets us apart. It's how we achieve justice. But we know it doesn't exist here. And where's that term come from, impartial jury? The original term wasn't impartial jury, as we know. It was jury of your peers. That was the term, jury of your peers. And where does that have its origins in? That comes from the Magna Carta of all places, okay? That's where it originally started. So in 1351, yes, we've now reached the historic part of this lecture. In 1351, England passed a statute that said none shall be taken by petition or suggestion unless it's by indictment or presentment of good and lawful people of the same neighborhood where such deed be done. So by the 14th century, not only were people accused of crime guaranteed a right to trial, but also entitled to a jury composed of people from that same neighborhood. Okay, let me tell you, if I could try all my cases, have my juries come from people who lived in West Oakland or East Oakland, good God. If I could try all my cases where my clients are charged with resisting arrest, and if you don't know, those resisting arrest cases are pretty much when the police beat the hell out of your client, and then they go back and say he was resisting arrest, or your client failed the attitude test, and they put a case for resisting arrest on him. If I could try those cases in East Oakland, West Oakland, those jurors, they would acquit every single client because they know what happens in their community. They would not blindly trust police officers. They would hold them to their burden. And that's what you have. So the Sixth Amendment, one of my favorites, love the Sixth, right? Rights Council, love it. But that phrase, jury of your peers, does not exist in our Constitution, does not exist in any of our great amendments, does not exist in any of our statutes, You will not find it in the Sixth Amendment. It is not there. And what the courts have done, they've taken that term instead, jury of whom peers, and said, we now need a jury pool that includes a cross-section of the community in terms of gender, race, national origin. That's what we're striving for. That's how they interpret jury of your peers. And we know that simply does not exist, because when we get through it, how we figure it out, when we get people to come to court, it passes through so many filters, right? The first filter is how you call jurors, whether they come from a list of DMV registers or voting or tax filers. Jury commissioners set up ways in which they're supposed to produce a cross-section. They have random selection techniques. They have, when the people actually get into the courtroom, there's so many other filters there, whether it be an excuse for a hardship, you can't afford to serve, or a challenge based on the prosecutor saying they're a cause challenge or a print challenge. There's so many ways in which jurors are excluded, and it usually tends to not favor people of color and black people. Right. Way back when, in 1875, there was the Civil Rights Act. And that was designed to protect all citizens in their civil and legal rights and provide for equal treatment in accommodations, public transportation, and it prohibited exclusion from jury service. That's what it was supposed to do. And we know it was really enforced and didn't really do that. And just a little more about history. Prior to this great act being passed, there was the Civil Rights Act of 1866. And I love talking about this because the Civil Rights Bill of 1866, they weren't focused on black people being jurors. That wasn't in their realm of consciousness. That wasn't it. The big issue then was whether blacks could actually be called as witnesses to testify against white people. That was what it was about. And there are so many great quotes and debate around this. Senator Hendricks, in 1867, discussing this bill, said this bill proposes not only that Negroes shall be allowed to hold office, but they should be allowed to sit upon juries. Now, of course, it was thought that they may be judges. The spectacle then that will be presented with the courts of Negroes to try cases. I'm like, I don't think those. He would have lost his mind thinking about a black public defender. That bill was vetoed by President Johnson. And he said that if Congress can declare by law who shall testify, and Congress can also declare, without regard to color or race, who shall have the right to sit as a juror or as a judge or to hold any office and finally to vote. We have to love the history of our great country. Right? James Foreman has a great law review article called Juries and Race in the 19th Century. And he discusses the original origins of the fight to get black people on juries. This was actually led by Republicans. I mean, things have really haven't changed now. That was actually led by Republicans. And what's interesting is that when they were doing this fight to get black people on juries, they weren't concerned about what we're concerned now. They weren't concerned about black people being convicted by all white juries. That wasn't what they were concerned about. They weren't concerned about the rights of black people. Instead, it's shocking, but they were actually concerned about the lawlessness of white people. The lawlessness of white people. They were more concerned about the crimes that were committed against black people. Because back then, all white juries were routinely and reliably acquitting white perpetrators of lynching and other racial acts of violence against black people. It happened repeatedly. In Texas, between 1865 and 1866, in 1 year, 500 white people were charged with killing blacks, and every single defendant was acquitted by an all-white jury. KKK members took oaths that if they ever got to serve on a jury and a Klan member was charged, they would acquit them. They would promise to acquit any white person accused of any act of violence against a black person. This is our history. The law jumped in and tried over and over again to provide assistance, but they failed miserably. Shroud versus Virginia was a big case. It was a huge case. First Supreme Court case that invalidated a statute that allowed for only whites to serve as jurors as a denial of equal protection under the 14th Amendment. It was a big deal. But after that case, as we know, black people were still excluded from jury service on numerous different reasons, whether it be the key man system, where states decided that only prominent citizens could be jurors, or they would put the names of black people into the bin, and they put them on different colors of paper so they could easily be discriminated against as they pulled out juries, quote unquote, randomly. Or they created tests where black jurors had to be of intelligence and experience and, quote unquote, good moral character. In Delaware, for example, although African Americans were technically eligible to be jurors, they created a rule that jury members had to be sober and judicious. And the state authorities found that almost no black people in Delaware were intelligent enough, experienced enough, or moral enough to serve as jurors. During this time, politicians also argued that it was better to have all white juries to administer justice instead of lynching. That was an argument. Politicians argued that over and over again. They said that instead of following the Constitution, instead of allowing blacks to participate, that should not be allowed because it would justify for return to lynching. And there are cases to support that. Ed Johnson, this case demonstrates that clearly. In 1906, he was sentenced to death. He was convicted. He was falsely accused of raping a white woman. He was convicted by an all-white jury. He appealed the case to the Supreme Court, and in his appeal, he challenged the racial composition of his jury. The court actually agreed to hear his case. They said, "We will hear your case." They sent a telegram back to Chattanooga where he was being held. The same day the telegram got there, the local sheriff acquiesced to the angry mob, allowed him to be pulled from the jail, and he was lynched. The angry mob left a note on his body to the Supreme Court, addressing the Supreme Court saying, "Come and get your N-word down." Ed's last words before he was lynched was, "God bless you all, I'm innocent." The court kept taking steps, and there was no real redress. Scottsboro boys, Norris versus Alabama. In 1935, the Supreme Court made a serious attempt to confront the rampant exclusion of African American jury pools. The case of Norris versus Alabama involved the appeal of one of the Scottsboro boys. There were 9 black teenagers who were wrongfully convicted of raping 2 white women on a train in Scottsboro, Alabama. They were convicted despite overwhelming evidence of their innocence. This case was big. It dominated the news back then. The teens were all tried by all white juries. In that case, the jury commissioner testified and said he did not know of any Negro who was generally reputed to be honest and intelligent, and who was esteemed in the community for his integrity, good character, and sound judgment to serve as a juror. There had been no black juror in that county in living memory. The Supreme Court reversed the conviction. It was a big deal because the court said they would no longer tolerate by exclusion, by law, or practice the removal of black people from jury pools. Swain versus Alabama, another case that was big. Robert Swain was a 19-year-old African-American young man, also convicted and sentenced to death for rape of a young white woman. In his case, he had 6 black people who were actually on his jury, in the jury pool. prosecutor used a peremptory challenge to exclude every single one. He kicked off every single black juror. Everyone. And the Supreme Court, in that case, held that there was no constitutional violation. None. They held that the Constitution does not require the judge to question why they did the strike, but instead, in order to prove a violation of the 14th Amendment, the defendant must prove systematic exclusion. That means that in case after case, whatever the circumstances, wherever the crime, and whoever the defendant or victim may be, they have to prove that the prosecutor is responsible. This case was decided in 1965. Okay? That was 5 years before I was born. That was the law of the land until Batson versus Kentucky. And yes, that is me, like, with here. At the time I was 16. Don't take a picture of that. What are you doing? That's my daughter, by the way. Funny. All right. We'll talk later. Batson versus Kentucky, the seminal case. And if you haven't done it, listen to this podcast called More Perfect. There's a great episode, episode 6, about Batson, and it's called Object Anyway. And so we don't really know, I didn't know the story of Batson until I listened to this podcast, but it's fascinating. Okay? So James Batson, who's pictured here with his mother, was a small-time burglar. Wasn't particularly good, but he got arrested in this case, and he was like, I didn't do it. I've done a lot of them, I didn't do this one. I want to go to trial. The prosecutor in this case was named Joe Gutman. Joe Gutman was 26 years old. Joe Gutman was not a good prosecutor. He had lost his first 8 jury trials. And he gets Batson's case. He's like, it's a straightforward case. 2 witnesses identify him. I can win this case. I can do this one. He takes it to trial. The case hangs 11-1. 11 for guilt, 1 for not guilty. The one not guilty was a black woman from James Batson's neighborhood. That was not good, right? Right. So Joe's like, you know what? This is a good case. I can win this case. I'm going to retry it. I'm going to try it again. He tries it again. They get close to the end of jury selection. There are 4 black people left. Joe Gutman kicks off all 4 black people. James is like, hey, you got to object. You got to object to this. His lawyer's like, I can't object. He's not doing anything wrong. It's like, no, you're my lawyer. You better object. He's like, you haven't done anything wrong. You object. Go back and forth. The lawyer objects. The court's like, well, following Swain, you haven't proved anything. You haven't done anything wrong. Batson was convicted, sentenced to 20 years in prison, appealed this case, went to the Supreme Court. That's how Batson versus Kentucky. The Supreme Court thought otherwise. They set out this 3-part test, 3-prong test, for Batson/Wheeler objections. I'm using this as defense versus prosecutor. That's the way I teach this one. But the defense must first establish a prima facie case of purposeful discrimination. Once that's done, the prosecutor must articulate some sort of reason, or racially neutral reason why they removed that juror or struck that juror. And the court makes a determination of credibility after that. That was the Batson test. For us as practitioners, that was huge. That was a big step forward. Historic, according to Justice Marshall. But in that opinion, he also stated this, that the eradication of racial discrimination in jury selection can be accomplished only by eliminating peremptory challenges entirely. So I've glossed over peremptory challenges quickly. Does everyone know what they are? Yes? Somewhat? Let me explain it real quick. In most cases, particularly criminal cases, when you're trying a case, there are what we call cause challenges and peremptory challenges. Cause challenges, there's no limit to them. You just got to show that person needs to be excluded because they can't be fair for X reason. He's a neo-Nazi or whatever. This can't be fair for some reason. Or the case is too close to them personally. They can't be fair. Other than that, both sides will normally have about 10 peremptory challenges, meaning I can kick someone off the jury as long as it's not based on race, gender, and so forth. Prosecutor has 10 normally, defense has 10. Those are our peremptory challenges. And that's what Batson was really trying to address. I don't agree with Justice Marshall about eliminating peremptory challenges, but his thought process there was completely foreshadowing what was to come. Because what was to come was prosecutors would learn very quickly how to get around Batson. Because all they had to do was give some reason, some excuse in regards to why they were kicking that black person off. And it couldn't be based on race. So they began trainings. This you can find this on YouTube. Jack McMahon, a DA in Philadelphia, gives this whole training about how to get around Batson and how to exclude black people from juries. Top Gun 2 was this training in North Carolina that was pretty much designed to exclude black people from juries. There were 10 reasons they taught their DAs to use if the defense made a Batson challenge made a Batson challenge saying you're excluding someone for race. Some of the reasons were inappropriate dress. That attire showed a lack of respect for the system, physical appearance, tattoos or hairstyle. Anyone who was a shell but they were resisting authority. Criminal history. They knew someone who was involved in the system. Or any other sign of defiance, sympathy with the defendant, or antagonism to the state. Those were reasons that they used, and they were in some ways, so many ways, code for race, that they were taught to get around race. Prosecutors in Dallas County, Texas, maintained decades-long policy of systemically excluding African American jurors, and they codified it in a training. And then we see how it played out in practice. Houston County, Alabama. In cases where the death penalty was imposed, prosecutors used strikes to remove 80% of black jurors. 80%. Half of these jurors were all white. The other half had one black jury member. Harrison County is 27% black. Jefferson Parish, Louisiana. Prosecutors struck more than 3 times as many black jurors as white jurors. And 80% of the criminal trials, there was effectively no black representation on juries. Jefferson Parish is 23% black. Same thing in Georgia. Prosecutors used 83% of the challenges against African Americans. That circuit was 34% black. Same thing in Dallas County, Alabama. And the courts did very little in applying the system with regard to how to apply Batson. In Tennessee, more than 100 criminal defendants raised Batson claims on appeal. No Tennessee court has ever reversed a conviction based on racial discrimination jury selection. In California, our big blue state, in 20 years, 93 to 2013, the California Supreme Court decided 102 Batson claims and found error once. Only once. So, I've been going on for a while. I've been going on for a while, and I've identified a big world of problems. A huge world of problems going historically to present day that highlights the fact that black people, people of color, are excluded from jury service. And it's intentional. Intentional. So what are we doing to fix it? How are we trying to fix it? And this is partly why I'm here. The first time I revealed, kind of publicly, what I call a 5-step plan to fix our broken jury system was, of course, on social media. That's how you do everything. That's how I found out when my daughter was in college. That's how I found out I was going to the Laker game on Friday. I had no idea. You know, actually just text her dad every now and then. That's it. So glad you're here, sweetie. Oh. They're on social media. So I'm pretty active on Twitter. I sent this tweet out. Today in Alameda County, a prosecutor used their very first challenge to remove the only black person on the entire jury. The only one. Our client's black. Our batch motion and request from the jury panel was denied. This is not justice. Black Lives Matter and Juries. So every now and then you send out a tweet, it lands, get some good responses, and then some people, I don't know, fire back a little bit. There's controls out there. So this person tweeted back. I support having more black people on juries. What is your plan to make it happen? You know that prosecutors have no control over who comes to serve. Yes, a little bit, yeah. So why do you continue to blame them? Because they keep kicking off black people. Why aren't you treating about the jury commissioner? And you did have a typo there, right? But neither here nor there. So I was going to let that one slide, okay? It bugged me, go let it slide. Anything that made it. Mr. Woods, provide the reason why that one single juror was excused. Post a transcript. Let people judge for themselves if the juror was rightfully disqualified. What are you scared of? Scared? Come on now. You want to talk the talk? What? You saying I'm all talk? And so this tweet came in. I was actually on a plane flying back from the East Coast to the West Coast, and I emailed the Wi-Fi on planes. Love it. Best mention ever. It's working. It's not working. Love it. I emailed a friend, showed these tweets like, look, this dude coming at me. Did I fire back? Yeah, fire back. All right. So that got us to putting the plan out there on social. And it was good to just have the platform be good. I've been asked about my plan to increase representation of black people on juries. This bill outlines 5 steps every state should take to increase representation of juries. See what's been done in California, what's left to accomplish. Jury of your peers, Black Lives Matter on juries. Let's dig in. First, step 1, eliminating the felony exclusion. Okay. Some people aren't even aware that this exists. 26 states and the federal government ban people for life from serving as jurors if they have ever been convicted of a felony. That's 13 million people in the United States are banned because they've been convicted of a felony. In Georgia, in 2011, there were 9 counties where more than half of all African American men could not participate in jury service because of felony conviction. In California, over 30% of black men could not serve as jurors. This is a lifetime ban, and think about how this works, okay? You can have been convicted of selling marijuana or possessing marijuana for sale as a felony back in 1965. Okay? You could have lived a completely lawful life, law-abiding life, done nothing wrong, been a business owner, right? Been on a PTA, done whatever, been a practicing lawyer, and you could not serve as a juror. That kept over 30% of black men in California from serving as jurors. As I said at the beginning, the most policed, most prosecuted, and most systemically excluded from the process. So we got to work. Op-ed testified we were able to get Nancy Skinner from the Bay Area. Senator Skinner's awesome. She's a beast. She carried the bill, SB 310. We got that signed into law in 2019 by Governor Newsom. That law, estimated, created about 2 million new eligible jurors in California. Okay. Step two, expand the list. Okay. Expand the list. Currently, California, before we did some work, California relied on only 2 things: voter registration and driver's license. And then the 7 states use voter registration, driver's license, and tax files. We were able to get legislation passed in California to add tax filers to it, but there's still more work to be done. There are other states that are much more inclusive. Vermont, voter registration, DMV, health and election records, the bill of rights kept by Department of Family and Children Services, census, telephone, shit. We should be doing Facebook, right? I mean, put Facebook and Instagram some good, right? There are other ways we can be more comprehensive about the way we pull in juries to serve. Step 3, challenging the flawed Batson-Wheeler process. Okay? Spent a lot of time talking about that earlier. That really has been one of the biggest barriers, in some ways, to get participation on juries for black people. So that one was a little bit harder, but we dug in, got to work. We modeled our bill here after the Supreme Court of Washington. It was done easier in Washington because it was something that was generated by the Supreme Court. The Supreme Court said, hey, we got a problem. Batson's not working. Prosecutors are using it to frequently remove black people from juries. So they started the work there. We were able to get the work done here. That African-American lady here, that's Secretary of State Weber, she was an assembly member before she became Secretary of State. She carried the bill. She is just a champion beast. This was a big lift. We pushed it there, op-eds, writing. We got to be on MC Night News West of Hope. The shit got covered by John Oliver, actually, okay? It was pretty big. And this lady here, do you guys know who she is? Liz Semmel from Berkeley Law Definitely Clinic, amazing. She wrote the white paper called Whitewashing the Jury Box, which is also amazing reading. I don't read a lot of books, but I read stuff like this. Phenomenal. Check it out. And we were able to get AB 3070 passed. What did AB 3070 do? The legislative findings are pretty incredible. If you have time to read them. But pretty much what they said is that the way Batson was done is racist. We're going to fix it. It's led to people of color, African Americans, Latinx people of color being excluded from juries. And we're going to dig in and fix it. And we're going to make certain reasons that prosecutors have used to kick black people off juries presumptively invalid, and they can't use them anymore. That list included distrust of law enforcement, negative action of law enforcement, a belief that officers are engaging in racial profiling, having close relationship with someone who's been stopped or arrested, people's neighborhood, having a child outside of marriage. It's crazy to think these were actually legal excuses that could be used to kick black people off juries, receiving state benefits, not being a native speaker, dress and personal appearance. So the way it has worked in practice is that you have a black juror who's being questioned during voir dire, and they say, I've been stopped by the police a lot. I might have issued them a question. That reason right there is a legal and valid reason to excuse that person from jury service. What's happening? Black people, I'd like to say, are being removed from jury service, not for any fault of their own, but for having a black experience in America. Every black person has had this happen to them. Unfortunately, most black people know people were arrested or stopped. They know families who are in custody. So just because of a black experience in America, nothing that was your fault, you could not serve as a juror. It was legally allowed for you to be excluded. Until now. All right. You're right, I did raise my voice. Number 4, step 4, paying people to serve. Paying people to serve as jurors. In California, we don't pay for the first day, and it's $15 a day after that. Connecticut, no fee for the first 5 days, $50 per day after that. Maine, $15 per day. Maryland, $15 per day. Various counties. New Mexico, which is interesting, $7.50 per hour. Right, per hour. Missouri, $6 per day. San Francisco this year got the legislation that passed a pilot program. They're going to be paying low-income people $100 a day for jury service. The pilot program hopefully will scale up statewide. I think the best solution is minimum wage for anyone who serves as a juror. We're spending billions of dollars on incarceration. Billions, billions, billions. We should be able to pay people a little bit to ensure that justice is done. Finally, juror outreach. Juror outreach, getting out there and talking to people about the importance of jury service. Will Snowden has a great program called the Juror Project in Louisiana. And what he does is go out to low-income communities. This is why it's important. We started a program in Alameda County. COVID has put a wrinkle on that, slowed things down. We're going to hopefully get that back up in 6 months or so. That's the 5-step plan. And so I did go back to that person. He doesn't listen to me. Sorry. So for the person who questioned me, this is not just talk. This is a relentless commitment to fight systemic racism in the criminal legal system and fighting for my clients, carrying out cages and mass incarceration. So, why is this important? Studies have shown that the mere presence of even 1 or 2 blacks in the jury pool results in significantly lower convictions for black defendants. Specific cases with no blacks in the jury pool, black defendants are convicted at a rate of 81%, and whites at a rate of 66%. 81%. From the jury pool, okay? Not seated, but the pool includes at least 1 black potential juror. Conviction rates are almost identical. 71% for black defendants, 73% for white defendants. Now, I'm not trying to see a lot of convictions, but I am trying to see equality and equity. Racially diverse juries compared to all white juries deliberate longer, discuss more case facts, raise more questions about what was missing from the trial, and are more likely to discuss race issues such as profiling and police misconduct during deliberations. That's what we want. What should we strive for? So, in this picture is Emmett Till. On August 28, 1955, Emmett was visiting family in Money, Mississippi. Emmett was 14. He's from Chicago. Emmett was brutally murdered for allegedly flirting with a white woman. His assailants were the white woman's husband and his brother. They kidnapped Emmett. They made him carry a 75-pound cotton gin fan. They took him to the Tallahatchie River. They ordered him to take off his clothes. They beat him to nearly to death. They gouged out his eyes. They shot him in the head. And then they used that barbed wire to tie his body to the cotton gin and threw him to the river. Some of you have seen pictures of the open casket that his mom had to show just the abuse that her son went through. An all-white jury deliberated for less than an hour. For less than an hour. And they should have heard it not. In 2017, Tim Tyson, the author of the book, The Blood of Emmett Till, revealed that Carol Bryant recanted her testimony, admitting that Emmett had never touched her, never threatened her, never harassed her, and said nothing could ever justify what happened to that boy. Mr. George. In 1944, in South Carolina, 2 young white girls were found brutally murdered. They were beaten over the head with a railroad spike. George and his sister were the last ones to see them alive. George was arrested. He was questioned in a small room alone without his parents. He was 14. And then police claimed that he confessed to the killing. After a 2-hour trial, 2 hours, in a 10-minute deliberation, who was convicted of murder and sentenced to death by all the jury. From his arrest to execution, it took 80 days. He was just 5 feet 1 inch, 95 pounds, the youngest person ever to be executed. 70 years later, he was exonerated. So, I came back to history, that's important. And I want to end this discussion with this. Last year, we were so old. 2020, we were so old. The industry's protesting. And I want to impart on people, if we can do this, we can do this. And this. We have to do this. We have to recognize the importance of this. We have to make sure that everyone in our community has access to this. We have to show up. There's an immediate way that people, individuals, like you and I, can have an impact on the system that is inherently flawed, that is inherently racist. This is how you can do it, have an immediate impact on someone's life. Then and there. So, as I said at the beginning, Black Lives Matter on juries. Black Lives Matter to juries. Black Lives Matter. So, thank you. Have you any questions? No questions, please. Any questions? Questions? Can be about anything, can be about talk. No, got a little bit heavy at the end. Questions, yes.
Thank you so much for being here and for that excellent discussion. I have a question about another type of thing that you were discussing that I've seen in person, even working as a public defender in Compton, for example. We have a really large jury pool bringing in people from like Long Beach, which is obviously expanding neighborhoods away from a neighborhood of your peers as your jury. And like, I guess, do you see inroads there? I know that's not in your 5-step plan, but like another mode of attack from that angle, or?
We've actually fought that battle and lost. We fought that in my county specifically, where for some time, quite a long time, our misdemeanor jury panels were composed of Oakland, Berkeley, that small location, throughout the county, and we lost that battle during COVID. And we've been fighting it for a while. It's not part of my plan, it's actually a really more difficult one to do. More counties are moving towards county-wide panels. Different in LA because it's so large, there's this general inertia to it. We put that against the area assessment. I think it's got really value. On the flip side, Orange County, County case there, oh boy, it's very different, right? Very different. You might want to change that jury composition altogether. Yes.
So, with the rise in progressive prosecution,
Woo!
I
All
know.
right. Ooh, good. Let's do it.
have you seen, like, we're right across the bridge from Chesa Boudin, like, have you seen a significant shift in jury compositions when the DA's office is led by someone who's ostensibly anti-carceral? And I know it's like a different county.
That's a really good question. I don't know. San Francisco is a weird beast with regards to the population there.
I don't know if you've been following the news recently, San Francisco was not anywhere near as liberal as it puts itself out to be. Seeing what Chase is going through and how there's just constant relentless attacks on his policies. Same thing's happening in Gospel here. I mean, it's you have this era of someone stealing crap from Walgreens and some retail theft, and also it's like hard on crime, right? It's like, I mean, it's like forget the drug on war. I mean, the war on drugs. It's the war on retail thefts. I mean, it is going to end up driving mass incarceration. So, with respect to your question specifically, I have lots of thoughts on regressive prosecution and regressive prosecutors. So maybe it's a different talk in the conversation. That's going to be filtered down to the troops, and I don't see that it happens. I think arguably, if you really want to fix some of this crap I'm talking about, sure, do what Marshall said. Eliminate peremptories for the prosecution. Right? You got the burden of proof. You should be able to do it with any toilet walk in the door. Right? That's your job. You've had a case that comes forward, has this whole police force that's investigated, had no investigators, the case is here, ready for you to charge it and get a conviction, do it. You should be able to do it in front of any toilet. Right? Or give them 2, give us 10. There's ways to work it around. I have not seen those policies filter down in the way I would like them to. But I'm also not practicing that jurisdiction. I'm in Alameda where we don't have that. Yeah. All right. So, yes.
You kind of just addressed my question a little bit, but I was curious to hear more about your opinion on the peremptory challenges and why you wouldn't support eliminating them entirely, because I guess I've heard a range of perspectives from public defenders, but I know, like, yeah, I'm curious about the balance of power between with judges and the prosecutor and stuff.
Sure. So if we eliminate peremptories, who will have the ultimate control of the site? Judges! That judge on the bench was just roomies with the DA like 4 months ago, right? I don't know if you know that the bench is not particularly diverse, right? The law we got passed around Bassett, AB 3070, unlike other laws, the Judicial Council came in and said, no, we can't implement that right away. We need a year to get trained. Like, you need a damn year to get trained on how to be not racist? What the hell? You need a year to figure this out? Are you kidding me? Every other law gets passed and implemented right away. You need a year to figure out how to tell prosecutors being racist in your state. What the heck? So, honestly, I think it's a horrible idea. I think it puts too much power in the hands of power, and it removes power from the people who are going through the system being alcoholics. It is so empowering, and just a pleasure when you're trying a case, and you include your client to that strategy, and you give them a voice to help them identify who they want to serve. I mean, it's, you have the conversation back and forth, that can't be replaced, and it should not be replaced. Our clients are stripped of so much power, and I really do believe that it's our job as defenders to empower them. Not to be their voice so much, but to amplify their voice. Right? Not to be complete control, but to give them the tools to control the process themselves. That's what we should be doing. And if you take away that, I think it's devastating for the defense. Yes?
Well, I just also wanted to express my gratitude for your presentation and for the work that you're doing. It was just really, really informative. My question is related to the idea of paying people. I'm from Seattle, so I know that up in Washington State that they pay people to be on juries, but one of the issues that I often heard was the challenges of, depending on which employer you had, you couldn't actually get time off.
Yes.
And just thinking again of like who is being most impacted by not being able to take time, I was just curious if you could talk about like more nationally, like are there any states or any places where you actually can for sure get time away for jury duty?
The states that do it best consistently are Vermont and Maine. Okay. They also got no damn black people. I'm sorry, but they do it the best. They pay the best. They have the largest pools. I mean, they do it really well. That's just
kind of like chicken, right? It's like, why they do it so well? Yeah, they do it best. Okay. Yep.
I was just wondering, my understanding is that AB 3070 went into effect relatively recently.
January,
Okay, so very recently.
yes,
Um,
because they did that year.
so, it's probably too early to say much, but have you noticed changes in prosecutors' use of peremptory?
Anecdotally, you see some changes where those reasons aren't put out there. Judges will question them more. AB 37 is really a great piece of legislation because it changes the whole burden. We just make the claim and they have to show why they're not including budget. It's a game changer. It almost shuts it down at the outset. From Washington, about the practitioners there, they said it had an impact. They're about 2 years ahead of us. And they said it was working really well. Yes.
I'm curious if there's an argument for the interim before these policies get adopted. I've seen it in the news that like defendants who've like done crime that is very notorious have like a venue change to another county because they're afraid that there'll be some sort of prejudice against them. Is there a way to flip that so that it can benefit your client, or like I guess you will be defending the defendant, but like is there a way to articulate that so it doesn't just protect white supremacists who engage in violence?
Not that I'm aware of, but you should write a law article on that. I mean, that's an interesting concept. I can see it fleshed out. That's an interesting concept. How to switch that.
Interesting.
How am I doing? What time were you in?
I would take one more question. Any more questions? We started a couple minutes late.
Thank you all for having me. Thank you for inviting me. Is my contact information somewhere? It should be somewhere.
Yes, we can share.
Okay. Any questions about anything, want to know about the office, come to talk on Wednesday, or just hit me up. Okay? Thank you.
And actually, he did my closing comments for me.
sorry.
No, it's totally fine. If you are already registered for Wednesday, you're good. If you have not yet registered and want to, you can still register online, so please do that because we are providing live. And then for those of you who RSVP'd, there's welcome back doors and we can take lunch on the way out. And even if you did